Hi guys, we'll be starting with Consumer Protection Act 2019. Now, Consumer Protection Act 2019 has replaced the Consumer Act 1986. Okay, it was passed in the Rajya Sabha in August 6, 2019. It was passed by the Minister of Consumer Affairs, that is our Shri Ram Vilas Paswan. It got its President's assent on 6th August 2019 and came into force on 20th July 2020. Now, it has very similar to the Consumer Act 1986, but with a few advancement and improvisations. Firstly, what is the object of the Act? The object of the Act is to provide timely and effective administration and settlement of consumer disputes. So it's a consumer centric act. It empowers the consumers in protecting their rights through various forums. Now, we'll be seeing what are the key differences from the Consumer Protection Act 1986 and what are the additions in Consumer Act 2019. First, very important is the regulator, the Central Consumer Protection Authority. First, like how for securities market, who is the regulator? It is SEBI. For the banks, who is the regulator? It is RBI. Okay, like that we have regulators, but for consumer cases, is there a regulator as such? Answer is no. In the earlier act, there was no separate regulator. Now we have a separate regulator called as a Central Consumer Protection Authority. We'll see what all this authority they can do. They can call for information, they can ban certain products, they can stop, they can ensure, take action against any unfair practices, and so on. So we'll be seeing second, very important, the consumer courts. Initially, if I'm a consumer, I had to file the case against any person who I feel has given wrong goods or services in the place where the defendant, that is the seller, resided. So if the seller's registered office was in Madhya Pradesh, I had to go to Madhya Pradesh and do that. So it was little bit in the favor of the sellers. But here it is an act where the complaint can be filed in the consumer court where the complainant resides or work. So again, a very consumer centric act where the consumer resides there. Earlier, what happens where the seller's office was located, there we had to file. So this is another advancement and favoring the consumers. So we are seeing how they are strengthening the powers of the consumers. Next, product liability. Now we've seen so many products, like there was some Galaxy Note which had exploded and causes loss to people. Now there was no separate provision in the Consumer Protection Act 1980 covering such kind of product liabilities, which has caused harm to the consumer. No provision in the consumer court could, no separate provision that you could approach, and you had to approach a civil court for product liabilities. Now, what has happened? Consumers can seek compensation for the harm caused by the product or service. Next, super duper important, okay, is this is a product liability is also important. Next is pecuniary jurisdiction. Remember, in the Consumer Protection Act, always we have studied that there were three forums: the state, the district, state, and national forum. डिस्ट्रिक्ट में अगर मैटर 20 लाख तक था तो डिस्ट्रिक्ट में जाता था. अगर 20 lakhs to 1 crore के बीच में तो it would go to the state and now to the national above 1 crore. However, the pecuniary jurisdiction has changed where they are saying very important. So this is the new limits that have increased. If the matter is up to 1 crore, the claim is up to 1 crore, then I will go to district. If 1 crore to 10 crores in national state and beyond 10 crores, it is national. The next fifth one, e-commerce. Now, e-commerce in 1986, they never thought a provision of online services, online sales, online contracts was there. So we had to bring in a separate provision recognizing that even a person who buys goods online is also a consumer. We needed a separate provision for that. So all rules for direct selling of e-commerce have been extended to e-commerce also, all the rules. Next, whenever there were disputes, going to the courts was a long drawn process. So we had to introduce something called as alternate dispute resolution. Now, ADRs is basically trying to make a settlement mediation between the two parties. So mediation cells were never stated, no provision for mediation cells, but now in Protection Act 2019, courts can refer the matter to certain matters which they think can be settled between the parties to certain mediators. Okay, so now let's see these provisions in a bit detail. These are the main key provisions. First is a regulator, okay, to that is your Consumer Protection Authority. So your Central Consumer Protection Authority is given. It is made to protect, promote, and enforce the rights of consumers. They can take cases with respect to unfair trade practices. They can even declare certain contracts and contractual provisions to be void altogether, to be unfair. If there is any misleading advertisements, we've seen so many misleading advertisements and consumers fall prey to it. They will take action on such, and whenever there is a violation of consumer rights, they have a right to impose penalty. Just assume like how SEBI is for securities law, for consumer related matters. Now we have a regulator called as the Central Consumer Protection Authority. Okay, they can investigate into any kind of violations, and it will be headed by the Director General. Now let's see what are the objectives and what are they empowered to do. So the Consumer Act Protection Act 2019 established this regulator with the objective to promote, protect, and enforce the rights of consumers. It is empowered to conduct investigations into violations. They can recall unsafe goods. So if I find out that there is a car and this car is not meeting up to the standards of safety, okay, and there is fire, because we've seen sometime in Nano, it used to catch Tata Nano, it was catching fire. Samsung Galaxy Note, it had exploded. Okay, so these are all dangerous products, so they can be called back. Certain kind of medicines which are unsafe, it will all be called back by the regulator. Order discontinuance of any unfair trade practice. If they find that any practice is unfair or misleading, it will be there. It will impose penalties on manufacturers. So manufacturers तो फंसेंगे ही because they are making harmful products. उसके साथ में उसके endorsers भी फंस जाएंगे. तो ये celebrity endorsement जो होते हैं, celebrity endorsement में क्या हो गया? Let's say there was Maggie का case. Maggie में there was let's say Amitabh Bachchan or Hema Malini. Now, what happened if they are endorsing these products which are harmful? So even the endorsers will be held liable. So endorsers nowadays have their own responsibility to check whether the goods meet up or no, because even they can be imposed. And publishers of such advertisements. So everybody is going to check that whether the goods are safe or no, because everyone will be roped in. Second, coming to consumer courts and e-filing. वेरी सिंपल, जैसे हम लोग ने डिस्कस किया ऊपर कि इट प्रोवाइड्स फ्लेक्सिबिलिटी टू द कंज्यूमर टू फाइल कंप्लेंट्स विद इन द jurisdiction लोकेटेड एट द रेसिडेंट ऑफ वर्क ऑफ द कंज्यूमर. तो जिधर कंज्यूमर रहता है, तो इधर सोचो कि मेरे रिलेटेड कोई रॉन्गफुल गुड्स आए, सेलर मध्य प्रदेश का है बट मैं रहता हूँ महाराष्ट्र में, और महाराष्ट्र में डिस्ट्रिक्ट फोरम है, तो मैं सीधा डिस्ट्रिक्ट फोरम में जा सकता हूँ, क्योंकि क्या लिखा है, आई कैन गो टू द jurisdiction in the consumer forum which is of the resident, which is in place of the resident of the consumer, so very convenient for the consumers. पहले नहीं था ये, ठीक है. और जो कंप्लेंट्स है वो इलेक्ट्रॉनिकली भी फाइल होगी, और ये अभी से अज्यूम करें कि वीडियो कॉन्फ्रेंसिंग भी होगा इसका, तो कंज्यूमर्स के ऊपर इतना हार्डशिप नहीं होगा. नेक्स्ट इज योर प्रोडक्ट लायबिलिटी एंड penal consequences. Now what happened, in the previous act there was nothing like a product liability. अब क्या हो रहा है, एक सेपरेट प्रोविजन डाल दिया कि कॉन्सेप्ट ऑफ प्रोडक्ट लायबिलिटी brings within its scope producers, प्रोडक्ट मैन्युफैक्चरर्स, तो मैन्युफैक्चरर तो फंसेंगे ही, अगर सर्विस प्रोवाइडर्स है तो सर्विस प्रोवाइडर्स भी फंसेंगे. ओके, तो इनकी लायबिलिटी होने ही वाली है. और लास्ट में प्रोडक्ट सेलर, तो मैं मैन्युफैक्चरर नहीं हूँ, मैं रिटेलर हूँ, होलसेलर हूँ, तो प्रोडक्ट सेलर भी बोल सकते हैं। तो ये सभी लोग फंस सकते हैं और इन लोग सबके ऊपर लायबिलिटी है, एंड दे विल बी हेल्ड लायबल फॉर ग्रांटिंग कॉम्पेंसेशन। तो अभी बोलेंगे किस बात का कॉम्पेंसेशन। तो देखो प्रोडक्ट लायबिलिटी क्या होगी। प्रोडक्ट लायबिलिटी मीन्स दैट यू विल बी हेल्ड रिस्पॉन्सिबल टू कॉम्पेंसेट फॉर इंजरी और डैमेज कॉज बाय डिफेक्टिव प्रोडक्ट और डेफिशिएंसी इन सर्विस। Next, basis for product liability action: manufacturing defect, design defect, any deviation from the specification, non-conformity with the express warranties, failing to contain adequate instruction for correct use, सर्विस प्रोडक्ट फॉल्ट और इम्परफेक्ट और डेफिशिएंसी। तो सर्विस प्रोवाइडर्स या मैन्युफैक्चरर्स या सेलर्स, अगर वो लोग ने कुछ भी गलती की और उनकी वजह से किसको हार्म हो गया, तो दे विल बी हेल्ड लायबल। नेक्स्ट, एनहांसमेंट ऑफ पेक्यूनरी ज्यूरिसडिक्शन ऑफ कंज्यूमर कोर्ट्स। नाउ कंज्यूमर कोर्ट्स को वो लोग क्या बोल रहे हैं, दे कॉल इट द कंज्यूमर डिस्प्यूट रेजोल्यूशन कमीशन। तो एक नया नाम है, rather than saying district forum, they are using the word district. They're calling it the district consumer dispute resolution redressal commission. ओके, यहाँ तक हम लोग ने देखा था 1 CR, फिर 1 CR to 10 CR जाएगा स्टेट के पास में, और 10 CR के ऊपर जाएगा नेशनल में 10 CR, और इफ इट एक्सीज 10 CR विल गो टू नेशनल। अब ये याद रखना है कि जब भी तुम एक कमीशन के पास में जा रहे हो, सोचो मैं अपील में जा रहा हूँ, फ्रॉम द स्टेट मैं अपील जाऊंगा, फ्रॉम द डिस्ट्रिक्ट अपील में जाऊंगा स्टेट में, और स्टेट से कुछ नहीं है तो मैं जाऊंगा अपील में टुवर्ड्स द नेशनल। अब जब भी मैं अपील में जाऊंगा ना, आई हैव टू डिपॉजिट, प्री डिपॉजिट 50% ऑफ द अमाउंट ऑर्डर्ड। तो अगर डिस्ट्रिक्ट ने बोला कि आपको 20 लाख रुपए देने हैं, तो मेरे को जब अपील में जाना है तो 10 लाख तो डिपॉजिट करना ही पड़ेगा, तो ही मेरे को अपील की फैसिलिटी मिलेगी। तो इससे क्या होगा कि पैसा तो देना ही है, एक कोर्ट ने ऑर्डर कर दिया है तो ओके। और जो टाइम लिमिट भी है फ्रॉम गोइंग टू द डिस्ट्रिक्ट टू द स्टेट इज, पहले 30 डेज था और अभी 45 डेज रखा है, has been increased from 30 days to this. So the limitation period for filing an appeal to the state from the order of the district has been increased from 30 to 45 days. नेशनल में भी हो गया, सब जगह 50% देना है। नेक्स्ट है मीडिएशन सेल्स। मीडिएशन सेल्स क्या होता है, ये एक ऑल्टरनेट मेथड है रिजॉल्व करने का, स्पीडियर सेटलमेंट हो जाता है केसेस के। complaints will be referred to the consumer commission for mediation wherever scope for early settlement exists and the parties agree to it. तो पहले मीडिएशन सेल्स क्रिएट करनी पड़ेगी, फिर बाद में कोर्ट खुद पार्टीज को बोलेगा देखो आप इधर आओगे, आपको तारीख पे तारीख लगेगी, बहुत टाइम लग सकता है, आप एक काम करो मीडिएशन सेल में दोनों पार्टीज कम टू सेटलमेंट, आपको बताएंगे कैसे होगा। सो मीडिएशन सेल्स बनाएंगे, सो द बर्डन ऑफ द कोर्ट विल रिड्यूस। सो कोर्ट के बाहर ही ऐसे मीडिएशन सेल्स रहते हैं, वो लोग जाके एक दूसरे पार्टी को समझा के एक कॉमन कंसेंट लेने की कोशिश करते हैं, अगर नहीं है तो मैटर वापस कोर्ट में आ जाएगा। सो द मीडिएशन विल बी हेल्ड बिटवीन द पार्टीज, देयर इज नो अपील अगेंस्ट सेटलमेंट थ्रू मीडिएशन। एक बार सेटलमेंट हो गया, दोनों पार्टीज ने साइन कर दिया, फिर तुम अपील में नहीं जा सकते। नाउ मीडिएशन, द स्टेट गवर्नमेंट shall establish consumer mediation cells to each district and state, whereas the central, तो ये state government काहे की बनाएगी, वो लोग state commission and district commission में mediation cells बनाएंगे, consumer mediation cells section 74 के हिसाब से, and central government make for the national commission के अंदर consumer mediation cell will be made by the central government. नेक्स्ट, रूल्स फॉर ई कॉमर्स। ना बहुत ही सिंपल है, द सेंट्रल गवर्नमेंट, और बहुत ही सिंपल है कि अगर मैं ऑनलाइन सेलिंग कर रहा हूँ तो इट इज माई ड्यूटी टू कंप्लीटली इन्फॉर्म द गवर्नमेंट एंड द बायर्स So e-commerce has to provide complete information. He has to give them so much information that they can take an informed decision. They will acknowledge the receipt of the consumer complaint within 48 hours and try to redress it within 1 month. Consumer protection rules 2020 are mandatory and not advisory. तो सारे ही sellers को ये follow करना है. Consumer Protection E-commerce Rules 2020. Sellers cannot refuse to take back the goods or withdraw the goods or refuse refunds if they are found to be defective, deficient, or delivered late, and if they do not meet the description of the platform. तो कितनी बार हम लोग देखते हैं, मे बी अलीबाबा के अंदर, अलीबाबा वेबसाइट के अंदर देखा, या जबोंग या मिंत्रा, उसमें फोटोज अलग होते हैं, फोटोज आर डिफरेंट एंड द रियलिटी इज डिफरेंट, राइट? तो इसमें क्या होता है, दे कैन नॉट रिफ्यूज टू टेक बैक द गुड्स, तो दे हैव टू टेक बैक. नेक्स्ट, अनफेयर ट्रेड प्रैक्टिसेस भी है कि जब भी कोई भी अनफेयर ट्रेड प्रैक्टिस लगा, द यू हैव द रेगुलेटर, ही कैन टेक एक्शन. So the state and the national commission respectively can declare any terms of the contract which are unfair to any consumer to be null and void. पेनल्टीज भी लगा सकते हैं. अब पेनल्टी क्या है, कितनी पेनल्टी, अप टू 10 लाख रुपीज ऑन द मैन्युफैक्चरर और द एंडोर्सर फॉर फॉल्स और मिसलीडिंग एडवर्टाइजमेंट, में ऑल्सो सेंटेंस up to 2 years imprisonment for the same. In case of subsequent offense, यही 10 लाख will increase to 50 lakhs and imprisonment of 2 years will increase to 5 years. Even celebrities will be roped in now. Celebrities can no longer be immune from the products that they endorse and now will be held accountable in case of misleading advertisements. And that is it. We are done with the chapter. Rest all from the previous act is very much the same.